It has become almost automatic. And we know that a data broker, as well as the various behaviors, are actually based on the big jump that we have experienced thanks to the digital and information technologies. And I think we know that this has got an implication for legal matters as well, and also has an impact on our reality, and therefore it is a requirement. And it is important that as MPs that cover the continent, I think the importance of technologies that have got to do with the digital world have a great importance for everything that we do. And I think we have to understand also their stranglehold on management of individual data and the right to rectify and to change positions, the principle of appropriating various rights and how to manage these data, I think, needs to be reaffirmed further. Furthermore, how to manage information technology requires that we manage them in such a way that we balance things out so that we promote the right of operators and make sure that the various weights designed to help us manage the various economic activities would then help us share better the responsibilities of individuals as well as the public authorities. And we would also have to make sure that we reconcile these various matters relating to the freedom of speech and individual freedoms, and also help us to fight against crime and to ensure that competition is based on free and fair rights. And also make sure that this information technology is a neutral tool that is designed to serve humanity. So it is incumbent upon us to use it so as to strengthen human rights and fundamental rights. So our parliament, therefore, are called upon to check how this is going to then impact our laws. Therefore, we will need to make sure that this is a tool that is properly used by both our parliament, the African Union, through model laws, so that the digital and information technology becomes a tool designed to promote a good governance, democracy, and the development of our continent. Dear colleagues, distinguished invited guests, before ending my statement, let me say that I salute the fact that you've come here in big numbers. And this is, I think, is a testimony to the importance that you attach to the activities of this parliament. And I hope that this is going to redynamize today the various objectives that are being pursued by the Pan-African Parliament. Let me also salute the presence of our resource people who have made the trip and have made themselves available to continue enriching our dialogue, and also to help inform our secretariat so that the Center of Human Rights of the University of Pretoria, which has helped us to conceptualize this activity, and by also bearing in mind the importance of the mission of our parliament, which is designed to cooperate with civil society. And I think that our secretariat is going to accelerate the formalization of a partnership which is going to be beneficial to both our institutions. Let me take advantage of this opportunity to inform you that I'm going to leave you after this opening ceremony to chair the meeting of the Bureau, which is going to start in a short while. But nonetheless, I will continue to follow the developments of your activities. And also allow me, therefore, to declare open this meeting on capacity building for members of the Pan-African Parliament on digital rights, democracy, and good governance in Africa, the role of national and regional parliaments. I hope that you're going to be inspired by the thoughts of Pascal, who said that science is blind. It is capable of serving all masters and respond to all appeals. both violence and charity and justice. So it is a slave who does not know what difference exists between good and bad as we know it in Africa. So this is a result of a science that terrorists use to try and destroy us. But it is also thanks to that science that we're going to develop our own continent. So information technology is going to be the foundation of our shared values, and our role as MPs and legislators, I think, is linked very closely to this science. So I formally declare open the workshop on capacity building for members of the Pan-African Parliament on digital rights, democracy, good governance in Africa, the role of national and regional parliaments. And thank you for your kind attention.
Je voudrais à présent demander.
Allow me now to request the audience to allow the president to leave us to go and take part in the meeting of the Bureau. And I wish to thank you, honorable colleagues. Before I leave you, let me say that you'll have a report prepared for you, because I think that heads of state and government expect us to do a lot, because we are required to legislate before the Malabo Protocol is adopted. So we have a meeting of capacity building, which is extremely important for us, because there is not only this field, because we want to hear the voice of the African Parliament on issues relating to climate change. We want the Parliament to come up with a model law on climate change, which is going to be of great importance to the entire continent. So this is one more activity for us, and I know that our countries are bedeviled by a number of problems.
Merci, honorable membre.
Thank you, honorable members. We'd like to thank you for your attention and your indulgence. I'm now giving the floor to Professor Frans Viljoen, who will speak about the role of human rights in democracy, elections, and governance in Africa, the African Union context. Professor, you have the floor. I call upon you to give your presentation.
Excellencies, members of the Pan-African Parliament, all protocols observed, ladies and gentlemen. I think my session should be relatively brief. We are running a little late, and also I think it provides the context for our discussion. So permit me to focus on 4 issues related to the topic of linking human rights, elections, governance in Africa within the context of the African Union. First of all, I would like to draw our attention to the primary human rights instrument of the African Union, the African Charter on Human and People's Rights, and show that it also has a very pertinent role in terms of democracy and elections. You would know that the African Charter had entered into force in 1986, so it celebrated 30 years of its existence. But the monitoring organ of the African Charter, which is the African Commission on Human and People's Rights, started functioning in 1987. Hence, it is this year that we celebrate 30 years of the existence of the African Commission, so it's also, I think, opportune to draw attention to its work. We know that all the African Union member states except Morocco had become a party to the African Charter on Human and People's Rights, so it is an important framing instrument. The second issue that I will deal with is to just trace very briefly the evolution of how human rights became closer linked to the notion of democracy and also consequently to elections from the 1963 OAU Charter into the documents that were adopted after the end of the Cold War and into the context of the African Union. The third is to focus on the primary African Union instrument that deals with issues around democracy and elections, which had been referred to, the African Charter on Democracy, Elections and Governance. Just highlighting a few of its features, and then lastly, in the fourth place, I will refer to the African Court on Human and People's Rights, which adds the dimension of binding judgments that relate to human rights, but in the process also to issues around democracy and elections. So as for the African Charter, we all know that the period between independence and the late 1970s was characterized by a variety of political regimes in Africa, and often not prominent among those were multi-party democracies. Most often we've seen autocratic military and one-party rule. But it was the end of exactly two of these kinds of military and authoritarian regimes that created an opportunity for the then OAU to adopt an African instrument on human rights. In the late 1970s, the government structures in Central African Republic and in Uganda were disrupted. The current rulers' terms came to an end, and many in the OAU saw in that moment an opportunity to advance the cause of advancing the African Charter on Human and People's Rights. I say this because it helps us understand that the African Charter is an instrument of compromise. It comes in a context where there is still a lack of democratic governance within domestic systems, but there is an opportunity to also embrace values of human rights. So in terms of democracy and the elections in the African Charter, we find that in Article 13 there is a provision that speaks to the right of every citizen to participate freely in the governance of his country, as the Charter had it in 1981 when it was adopted. However, the African Charter was principally modeled in terms of this provision on the American Convention of Human Rights, which was adopted in 1969 by the Organization of American States. And this provision appears exactly in the American Convention. But in the American Convention, the provision is complemented by a further sentence that provides for the right to vote in genuine periodic elections and for the principle of universal equal suffrage. That clause was omitted from the African Charter. The African Charter also includes a so-called clawback clause, a clause that seems to allow national law to detract from the rights in the Charter, in that it provides for the right to be exercised, Article 13, in accordance with national or in accordance with law. The African Commission, in the exercise of its mandate, had, however, largely overcome any of the caveats that one may have about the formulation of the right in Article 13. In the exercise of its mandate, the Commission embraced an understanding of the right to participate freely in governments as closely linked to the notion of multi-party, functional, effective democracy. It did so, and it does so in the examination of its state reports. When states report to the African Commission on Human and People's Rights, the Commission often engages on the systems in place to secure an effective multi-party system in place. The Commission also does so in respect of adopting resolutions. For example, in 2016, last year, the Commission, the African Commission, adopted a resolution on elections in Africa, calling on state parties to ensure compliance with the African Charter and other international and regional instruments during the electoral process, and calling on states to ensure the equal participation of women in elections, calling on states to ensure the equitable access of state-controlled media, for all political entities participating in elections, and calling for the independence of institutions dealing with the management of elections. So the African Commission took this rather minimalist mandate to make the issue of democracy, human rights, and governance in terms of multi-party elections part of its mandate. But as you know, the Commission also has a mandate to examine and decide on individual complaints or cases. And in this part of its mandate, it had also shown the link between the human rights, the Article 13, and issues around elections and governance. I refer to three types of cases decided by the African Commission. The first was a case against the Gambia that was brought by the deposed President Jawara. After he returned to the Gambia, he brought a case against the new regime in the Gambia because in post-Jawara Gambia, ministers from the previous regime were excluded from participating in any political processes in the Gambia at the time. We are talking about the 1990s, obviously. The African Commission found that this exclusion was a clear violation of the African Charter, Article 13. In another series of cases, the African Commission found that to exclude certain persons from running for high political office also constitutes a violation of Article 13. We have the case of the media of the Legal Resources Foundation and Zambia, in terms of which a part of the Constitution of Zambia was declared to violate the African Charter because it required someone at the time, a number of declarations are adopted to reinforce democracy. The first in this regard that could be mentioned is the 1990 Declaration on Political and Socio-Economic Situation in Africa and the Fundamental Changes Taking Place in the World. In this declaration, the idea, the notion of political participation by the broader population in an effective way in governance and governance structures and in the development of each of the countries is reiterated. The declaration calls on the further democratization of Africa and the consolidation of democracy to the extent that it had taken place and taken root. In 1997, at the Harare summit, the OAU leaders also called specifically on the return to constitutional democratically elected governance in respect of the overthrow of the democratically elected government in Sierra Leone. And that perhaps led in 1999 to the adoption of the Algiers Declaration on unconstitutional changes of government. Because in the interim period between the Harare summit and Algiers, a number of unconstitutional changes replacing democratically elected governments again took place. So in the Algiers Declaration, once again, the OAU embraces the values of democracy, governance, and it calls on the restoration of the legality of democratically elected governments. In a sense, the pinnacle of that process is reached in 2000. I'm sure all of you are familiar with the Lomé Declaration on the framework of the African response to constitutional changes of government, in which concern for the resurgence of coups d'etats in Africa was expressed. And the notion of unconstitutional changes of government was defined as fourfold. That an unconstitutional change of government takes place when a democratically elected government is removed, 1, through a coup d'etat, 2, through mercenarism, intervention, and 3, through political dissidents taking government through force. A fourth ground was added, namely the refusal of the incumbent government to abide by the outcome of a fair and free election. In 2001, we have the adoption of the AU Constitutive Act, and the AU Constitutive Act, in a sense, is then a process of consolidating in a legally binding format the principles that have been expressed before. It brings in Article 13 also in a formal way the principle of suspension of member states for unconstitutional government, as you very well know. It reiterated the principles around which the AU is founded as peace, security and stability on the one hand, but certainly also democracy, rule of law and observance of human rights on the other. The AU then also adopts the Peace and Security Council in 2002 through a protocol. The Peace and Security Council, in a sense, although it is focused on security and peace, obviously, it is also aimed at ensuring the conditions for peace and security are observed. So it makes a very pertinent mention of the importance of democracy, human rights, and good governance within countries, and link that to peace and security. In 2003, we have a meeting, important meeting between the AU, others, and also the Organization of American States. The OAS, the states of Latin America and North America together, had adopted an Inter-American Democracy Charter, and that charter inspires, in part, the adoption then later and the drafting of the African Union's Charter on Election, Democracy and Governance. As you know, it was adopted in 2007. It took quite a while for it to enter into force, to have the 15 states. By 2010, there were only 3 states that had ratified the African Democracy Charter, but there was then a surge, and in 2012, 15 states had ratified the African Democracy Charter. Today, it has been ratified by 30 of the AU member states, and checking the list on the AU website this morning, it was interesting for me to note that 2 of the countries mentioned here, Kenya and Senegal, are not state parties to the African Democracy Charter, the states that had a recent election. We also have, in this context of evolution, the adoption of the institution of NAPAD and the African peer review mechanism, because as you know, the peers review the performance of states there, states that voluntarily agree on the basis, among others, of democratic governance and human rights. Let me then, in the third place, turn to the Democracy Charter itself and just highlight a few provisions that perhaps serve as a background to our discussion. The first is that the point should be made that the African Charter on Democracy, Elections and Governance of 2007 locates itself in this evolution that had taken place. It is not something essentially new. It is a codification of values that had been espoused over time, increasingly within the OAU and ultimately within the African Union. So it talks of reaffirming certain values. It talks of enhancing democratic practices and of institutionalizing further transparency and accountability. The African Democracy Charter also clearly makes the link between human rights on the one hand and democracy on the other, making the point that human rights, equality and inclusion are preconditions for a just and democratic society. But on the other hand, that a stable democracy is a necessary precondition for the full enjoyment of human rights. And this is set out very clearly in Article 10.3 of the Democracy Charter, if I may just read it to us. State parties shall protect the rights to equality before the law and equal protection by the law as a fundamental precondition for a just and democratic society. The African Democracy Charter obviously also calls for the holding of free and fair elections on a regular basis, and it calls on states that will be party to establish independent electoral commissions. In Article 17.1 specifically, it calls for the establishment and strengthening of independent and impartial national electoral bodies responsible for the management of elections. It also protects democracy in the sense that we have seen in the Lomé Declaration that unconstitutional changes of government are frowned upon. The 4 grounds that I highlighted that appeared in the Lomé Declaration are now in the African Democracy Charter enshrined formally, but 1 ground is added, and that ground is the ground that any amendment or revision of the Constitution or legal instrument which is an infringement of the principle of democratic change of government is also considered to be constituting an unconstitutional change of government. So constitutional change aimed at undermining democratic change. The African Democracy Charter also calls on states to make sure that they have institutions in place that will enhance effective public administration, effective parliamentarian processes, the independence of the judiciary. So making the point that democracy and elections that need to serve a broader principle of inclusiveness need to be embedded within a context of the observance of principles around the rule of law. As far as the media specifically is concerned, the African Democracy Charter sets out as one of its objectives the promotion of access to information and the freedom of the press in Article 2. It also calls specifically on states on